Hey folks, this is Rob Wells here with you from the law office of Robert M. Wells. Our office helps out landlords and property managers deal with their landlord-tenant situations and problems. In this video, we're going to talk about whether or not if your tenant gives you notice, let's say they give you 30-day notice that they want to end their month-to-month tenancy, does that qualify as just cause under the Tenants Protection Act should your tenant not move out? Now, before I begin, though, landlords, property managers, if you run into a situation where your tenant gave you notice that they were going to vacate, but then they didn't move out and you need help with dealing with that situation, please feel free to reach out to us below. Now, let's begin. Now, to answer the question about whether or not if your tenant gives a notice, let's say they gave a 30-day notice saying that they're going to move out by a certain date or within 30 days of that notice, and if they don't do that, is that just cause under the Tenants Protection Act to proceed with an eviction? The answer is yes. That was actually codified in the Tenants Protection Act as one of the just causes in the act. And to step back, to give you a little history about what the law was before the Tenants Protection Act, it's always been the law that if a tenant has given you notice that they want to terminate their month-to-month rental agreement with you, or if they say, hey, you got a 1-year lease and they gave you a letter saying, hey, you know, we're not going to renew the lease, and then they fail to leave, that would basically the grounds for an eviction, because under the Code of Civil Procedure, it works both ways. I know we talk about a lot of times we're talking about landlords giving tenants notices of ending the relationships, but from time to time, you'll get it goes the other way around. And if a landlord, gets served this notice, and or accepts the surrender of the tenant, and the tenant doesn't move out, that's immediate grounds for eviction right there. If your tenant told you, hey, I'm going to be out by August 1st, you get the notice of that. They don't leave by August 1st, then landlord doesn't need to give another notice. Landlord can rely on tenant's notice to proceed with an eviction. Now, there are a couple of different caveats. I know for a lot of my owners that get emails or text messages from tenants, you guys are probably going to wonder if that qualifies. The answer is going to be no, and I'll give you two reasons. I'll break it down for you. So the first, there are two ways actually that a tenant could give you lawful notice where you could just file an eviction, and this is cause to do the eviction. The Tenants Protection Act basically incorporates Civil Code 1946, and what Civil Code 1946 is how landlords and tenants can terminate their relationships with each other. So the main requirements of a termination notice is it has to be in writing. Okay, and it has to be served in a manner that's lawful, basically, to effectuate that termination. Based on Civil Code 1946, there's only three ways that you can terminate a tenancy with a written notice. It's one, you have to give it to the landlord in person. Two, you can give it to another adult. I guess, let's say a landlord runs a business and the tenant gives the notice to one of the employees. Or three, you could certify mail the termination notice to the landlord. I think technically you could post and mail the termination notice, but I haven't heard of that. The main forms would be, hey, you get it in person, or you get a certified mailing of the notice saying, hey, landlord, we're gonna, I'm giving you my 30 days. I'm gonna buy a house or something, or I found a new place to live, so I'm gonna be leaving your place. That's one form. So that's why an email or text message is not gonna work. Informally, if your tenant keeps their word and you take the keys, that's great. But legally, if you came to our office here and you told me that, I'm going to tell you, hey, we're going to have to get the tenants to at least acknowledge that in writing, that type of deal. Second option you can do is the code refers to Code of Civil Procedure 1161 subdivision 5, which talks about a tenant making a written offer of surrendering the possession of your unit, and the landlord accepts that in writing. That's pretty broad. I think what the Code of Civil Procedure and the Tenants Protection Act are envisioning are, your tenant may write you a letter saying, "Hey, landlord, I wanna surrender the your unit for whatever reason it is. I can do it by August 31st, 2022. Let me know if this is gonna work for you." And if the landlord responds in writing, "Yes, I accept your surrender of the property. I expect you to be out by August 31st. That's great. I'll tell you a little trade secret that we do here. So a lot of our move-out agreements, I incorporate this exact language out of the Tenants Protection Act about the in our move-out agreements, because I have a lot of landlords and tenants. Sometimes they can reach a mutual agreement of terminating the tenancy. Basically, having a move-out agreement, in my opinion, would qualify as a written offer accepted by the landlord. And what we do on our move-out agreements is we specifically state, for purposes of this agreement, the tenant is making a written offer and the landlord is accepting it. So if the tenant doesn't move out per the agreement, then this would qualify as just cause of filing the eviction case in court. For some of my legal beagles out there, the folks that know the legalese, to have a basic contract, you have to have an offer with a promise. In this case, it would be, tenant, I promise to move out by a certain date. And then the landlord, can accept that offer by saying, yes, I'm going to take, I accept your surrender. And if there are other terms in the move out agreement, in legalese, we call that consideration. It's a promise for a promise. A lot of times my landlords will put in, hey, if you move out by this date, I will pay you cash. That's, the non-legal lease term is cash for keys. I don't think we have a legal term for it. Well, consideration would be the term, a promise for a promise, basically. And if the tenant didn't live up to that promise, well, guess what? Per the Code of Civil Procedure and the Tenants Protection Act, you could go into court. So that's kind of how those work, and that's kind of how to write my move-out agreements if you're doing a move-out agreement prior to filing an eviction case in court or an unlawful detainer action. So just some things to think about. This does qualify as just cause. And if you have a situation where you may have a voluntarily, you can get your tenants to voluntarily agree to surrender the property, or they've given you notice and you need to know what to do next, please feel free to reach out to us. And until next time, folks, we'll talk to you then. Thanks.